All right, perfect. All right, welcome to Beyond TM, protecting your brand with trademarks. I want to welcome you officially. Thank you guys for those of you who have joined live and are introducing yourselves in the chat. Welcome from DC. We got DC in the house, North Carolina, Texas. If you see me looking over here, it's because I'm on chat with my phone because I can't see it on my laptop. But welcome. Okay, we're going to jump in and get started because we have a lot to cover. But let me tell you, make sure you have access to the chat because there is going to be a time where we're going to be interactive. Okay. Hey, Arizona, welcome. All right, so welcome. All right, so let's talk about our agenda tonight. What are we going to cover in this webinar? We are going to be talking about brand define. We're going to define what a brand is. I'm also going to give you the legal definition of a trademark. It's a legal definition. I am going to go over the difference between a brand versus a trademark so you walk away understanding what is what and you can identify it in your own business. We're also going to cover how trademarks are born and strategies to create a strong brand that can be trademarked. Okay, give me one moment. I'm hearing an echo and I want to make sure. There we go. All right. We're also going to cover mistakes to avoid when creating a trademark ready brand and steps to move beyond TM. We're also going to cover power and benefits of a federal trademark registration. And as a bonus, stay to the end. As a bonus, we're going to talk about brand protection strategies that go beyond trademarks. Now, we do have an interactive portion because, I like to be interactive, y'all. It's late at night. I want to make sure the blood is flowing. And so for those who participate in the challenge and the winner of our challenge is going to receive a gift from me. So stay tuned, stay to the end, and the bonus is towards the end. All right, some housekeeping. First and foremost, grab something that you can take notes with, whether it's pen or paper, you old school, or whether or not you have your electronic device, whatever it is, make sure you have it to take notes. For the next 90 minutes, I want you to lock in with me, okay? For 90 minutes, I'm gonna try my best to get us in and out in 90 minutes. Also, please hold all questions until our Q&A section. So make sure you write your questions down and hold them. I'm not going to be able to see the questions as you put them in the chat. So just hold them off so I don't have to scroll up and down, okay? Now, for everyone who you're here, welcome. Make sure you introduce yourself in the chat, where you're tuning in from, and tell us about your business because look, we all are here. We're all in business. You never know who needs what you have. Our next part of housekeeping is this is not a how to trademark DIY training, okay? I'm not teaching you how to trademark how to do it yourself, but I am going to give you the foundation that you need to understand in your own business, especially when you're in the branding process, how to make sure you come out of that with a trademark ready brand. Next, prepare to participate in tonight's challenge. Movement is required, y'all. Movement is required. Engage and talk back to me in the chat. So I'm going to have the chat open, but I won't be answering questions. So write your questions down on a piece of paper and save them to the Q&A section. But talk back to me in the chat. I'm going to be able to see what you're talking about. I want to talk to you, okay? Also, there is no judgment here. You are smart, you is kind, you is important. So ask your question. Even if you're not sure if you're asking it the correct way or if you're not understanding, that's okay. Just ask. You didn't go to law school, I did. And even though I went to law school, I still ask Google sometimes. So just be free, okay? The replay, there's always a question about a replay. The replay will be available for 2 weeks for this, okay? You'll have 2 weeks to have access to the replay. So for those of you who maybe you can't stay the entire time, look, life goes on. For those who registered but they weren't aren't able to attend live, they will have 2 weeks have access to the replay. Now, for those of you who stay to the end, again, I have a gift, and I also have a surprise gift for the winner of our challenge. So for those of you who came in, make sure you introduce yourself in the chat. Make sure that you tell us where you're tuning in from, what your business is, and make sure, again, you talk back to me as we're going through, but save your questions for the Q&A. All right, so now, give me one moment. Here we go. All right, I was getting a little feedback. All right, so legal, got to cover the legal. This webinar is legal education only, and all of the materials and answers to questions are not legal advice. If you need trademark legal advice, you can schedule a consultation with my law firm through our website. But by you being in this webinar, watching the replay, or participating in the Q&A session, there is no attorney-client relationship between me and you, your business, or my law firm. And you are solely responsible for all actions you take on the information in this webinar, as well as Q&A and any materials that you may be receive as a part of staying with us to the end or participating. So a little bit about myself, because many of you have never taken any webinar with me, you've never heard of me. And so I want to briefly introduce myself, and then I want to jump into tonight's material because we have some things to cover, y'all, about trademarks. So welcome again. I am Shayla Jackson. I am a trademark and business attorney. I'm also serve as chief legal counsel for some of my clients, and I am the CEO and founder of my law firm, Legacy Legal and Consulting Firm, which is hosting this webinar tonight. Legacy Legal and Consulting Firm is a virtual law firm for purpose-driven CEOs on the go. For those CEOs who are serious about building a profitable, sustainable, and scalable business that leaves a legacy of generational wealth, we are the law firm for you, because as you're on the go, you need access to counsel who is on the go with you. And so in my law firm, I have the privilege of helping my clients protect their brand, build a legacy, and secure their wealth in a number of ways. But I'm not just an attorney with a law firm. I also have another company. I'm a business owner, y'all, called 180 Contracts, which is an attorney drafted contract template company for small business owners. And so I'm not just an attorney. So whatever preconceived notions you have about attorneys, cast that off. Before I was an attorney, I had a business. Before I went to law school, I had a business. So one thing about me to know, y'all, I cannot believe that this year marks 10 years since I have been licensed to practice law. It also marks 10 years since I graduated from Georgetown Law School. And so I graduated from Georgetown. I also graduated from University of Maryland College Park. But when I was at Georgetown Law, I started practicing law after my first summer. So after my first summer, I had my own clients, and I started focusing, my focus was on education law, but also criminal defense law. And so throughout my tenure at Georgetown Law, that was my focus. When I graduated, I shifted to business law. But when I was at Georgetown Law in my second year, I started teaching. So I actually started teaching at DC High School, at Wilson High School, if you're familiar with DC, and Bell Multicultural High. I taught their law to the DC high school students. And I also taught law to DC youth who were on probation through DC court. Now, that teaching bug got with me, y'all, because one of the things I love about teaching is the ability to break down legal concepts that may seem complex in a way that makes the law easy. And so I'm hoping that by tonight, you're going to see that, because you did not go to law school, but you need to be legally savvy to protect your business. Now, I graduated from Georgetown Law, and then after that, I came back and I spent 1 year in the clinical teaching program where I taught Georgetown Law students how to teach law. So I'm trained, I understand teaching methodologies. Also we all learn differently. So you're going to see some visuals and hear some examples to help you understand the law and bring it home. I'm a Maryland native. I'm also an author. and I've been featured to write in Baltimore Business, featured in Baltimore Business Journal, and I've been a speaker for other organizations as well. But one thing that I want you to understand is that before I went to law school, I had a business. I had a photography business, then I had a speaking and coaching business. So I understand business, and I want to make sure that you understand that so that you don't get here thinking you're just talking to some attorney who went to law school but doesn't understand the business. All right. So that's a little bit about me, a little bit about me. So let's get into tonight's materials. Beyond TM, protect your brand with trademarks. So first and foremost, I have a question for you. I told you, get ready to participate, and I want you to drop your answer in the chat. What is your brand investment number? What is your brand investment number? How much money have you invested in your brand? Whether it's from the design, such as your logo, whether it's designing the product labels, marketing materials for your services, getting your website up. How much have you invested in your brand? And so I want you to drop in the chat the dollar amount, but I also want you to put the number of years you've been in business. So for example, I did a training years ago, and one person in the training said they spent $20,000, but they had been in business not for 5 years. They had been in business for a little bit longer than that. But for this example, I put $20,000 in 5 years. So drop it in the chat. What is your brand investment? And you can just estimate. Is it $5,000? Is it zero? Is it 10,000? What is your number? Drop that number in the chat. All right. Talk back to me, y'all. What's your number? What's your brand number? Okay, 5K. Dion, 16 years, 6,000, 1.5 years. Okay. What's your brand number? $500, 2 years. Okay. See, we all have different brand numbers, how much we've invested, different numbers. Okay. So now what happens if your brand goes bye-bye? If something were to happen today and you had to start all over from scratch, you had to throw it all away, your 5K after 16 years, your 6K after a year and a half, your $500 after 2 years, how would you feel if you could never use that brand again? I want you to drop your answer in the chat, or you can use an emoji or a GIF. What would be that emotion if your brand just went bye-bye? You could never use it again. How would you feel? Devastated. Over it. Look, I'm just over it. Look, I would be extremely upset. Okay, upset. Oh, I love that emoji. I probably would be crying. I probably would be crying. Okay. I want you, the number that you have, even if you didn't, beside myself, absolutely. Even if you didn't drop your number, I want you to keep that number in mind as we go throughout tonight's webinar. And the reason why is because when we talk about brand protection does not start with trademark registration. It starts before you ever start branding. Brand protection starts before you ever start branding. And in the name itself, in brand protection, it's in order. Before you get to protection, you have to get to brand. So what is a brand? A brand is the public image, reputation, identity for something to be marketed or promoted. And so a brand is not just your logo. Oh, it's not just your logo. A brand is a combination of the design elements, the brand identity, a reputation, which includes your logo, brand colors, fonts, keywords, story, your brand story, the aesthetics. Y'all probably been on social media where you see the aesthetics that just look amazing, right? It's a part of the brand voice, designs, images, even the quality of your products and services are a part of your brand, and the public opinion and perception, and as well as your reputation. Many of us have decided whether to go to a restaurant or not to go to the restaurant just based on the reviews. We saw the reviews and said, that ain't it. No, I'm just right. We even do that with people who we're thinking about working with. We look and look at their Google profile and we say, nope, I'm not spending my money there. And so your brand is bigger than just the visual aspect. I want you to expand your concept of brand, because what a brand does is it helps you stand out in the marketplace. It helps you stand out in the crowd. And so the reason why the quality of your products and services is there is because how many of you have ever purchased something from somebody? Everything else looked great. The brand was great. It got you to buy. And then you got the product or service and said, this is trash. This is not up to par. I absolutely will never, ever, ever buy anything else from this person again. The quality of your products and services. And I will even include this. Even how you do business, your customer service is a part of your brand. So your brand is much bigger than what your logo is. Your brand is the identity, the public image, your reputation of what is being marketed. And there's a difference between your brand and a business. We're talking about the brand, but the brand can be, you can be a brand. You can be your own brand, and then your business can have a brand as well. And so you can have a brand, but not a trademark. You can have a brand, but not a trademark. And so, in order for us to understand this, we have to we have to identify what is a trademark. If you can have a brand and not a trademark, then what is a trademark? So, how many of you have ever gone on a road trip? How, you just talk to me in the chat. Have y'all been on a road trip? Look, my family, when I was young, and they still do, we used to get in the car early in the morning and get ready to travel from Maryland to South Carolina to go visit the cousins, the great grandparents, all of that. And so when we were on the road, my grandfather used to have this rule where we ain't stopping until it's time to get some food, which means, look, love road trips. I know that's right, Sarah. I love road trips as well. But we ain't stopping until it's time to get some fruit, which means if you got to go to the potty, you got to hold it. Now, in the extreme circumstance, you got to go. We used to pull over the side of the road. I don't know about y'all, but I grew up with some country folks. You pull on the side of the road and yeah, pull on the side of the road. But oftentimes what's happening is when you drive, I want you to imagine that you're on a road trip. Look, Mona, you know it well. You're on a road trip, and in the distance, look, the kids in there. I gotta go to the potty. I gotta go to the bathroom. It's time to eat. I want you to imagine that in the distance, what you see is a yellow M in the distance. What do you recognize that as? If you see a yellow M in the distance, what do you recognize that as? Oh, I see you, Sarah. I see you. I see you, Amani. Yes, McDonald's. That is a trademark. When I see it, I know it. When I see it, I recognize it. I recognize what that is and what it's associated with. And so a trademark is a mark that acts as a source identifier on a product or service that is used in commerce. And so, in order for there to be a trademark, the mark has to be distinctive and not confusingly similar to an existing mark. I'm giving you these legal terminologies and then I'm going to break it down for you. And so you're familiar with this. All right. Look, you're gonna be surprised. And so you're probably familiar with McDonald's, the Golden M, the bitten apple for Apple products, Nike, the Nike swoosh, look, Visa, MasterCard, but even social media. All of these are marks that identify a product or service, and they are being used in commerce. And so trademarks are not created through trademark registration. Trademarks are not created through trademark registration. So how the trademarks are also not created when you register your business name with the Secretary of State. So when you go to create your business, you're not creating a trademark. If you file a trade name, which is not a trademark, or a DBA, which is another name for a trademark, that is not a trademark. So when you file a trade name or DBA, you're not creating a trademark. You're also not creating a trademark when you go secure your social media handles or purchase your website domain. None of these matters when creating a trademark protectable brand. So again, a trademark is a mark that acts as a source identifier on a product or service that is used in commerce, and it's distinctive and not confusingly similar to an existing mark. Because then, how are trademarks born? Well, first and foremost, a mark is born in the branding process. I didn't say trademark, I said mark. A mark is born in the branding process, and it has the potential to become a trademark. And so a trademark is born when you've met the Fab Five requirements. You have to meet all Fab Five requirements. So, what are the requirements? I'm glad you asked. But before we get there, we got to figure out what a mark is, because before you get to a trademark, you have to have a mark. And so, a mark can be protected as a trademark. And so, what are some of those marks? A name, your business name, your brand name. So, Google. That's a mark that can function as a trademark. Slogans, taglines like just do it. Logos, symbols like the bitten apple or the golden M. Colors can actually be a mark that can be trademarked. The Tiffany blue is trademark. The UPS brown is trademark. Scents, excuse me, let me go back. Sounds can be trademarked. The NBC chimes is actually trademark. Scents, Play-Doh. The scent of Play-Doh is trademarked. Shaped, the Coca-Cola bottle. The glass bottle. You see the shape, you recognize it. It's a mark that can be trademark, a shape. And then there's a combination, a composite that is a mark that can also be trademarked. So first you have to have a mark, and you create these marks when you're in the branding process, that creative process. But a mark is not automatically a trademark, but it has the potential to become one. And so in order for a mark to become a trademark, it has to meet all of the Fab Five requirements. The first being it has to be distinctive and not generic, descriptive, deceptive, vulgar, or have profanity in it. If it's generic, descriptive, deceptive, if it's vulgar, if it has profanity in it, chances are it's going to be denied as being a trademark. Trademark protection is not going to apply. Another requirement of the Fab Five is that it has to be placed on a product and or service. A product and or service. It also has to act as a source identifier. So it can't just be used for decoration. If it's just decoration, that's not going to be a trademark. So it has to act as a source identifier. Go back to our example of the road trip. When I see that mark, I know its source. It also has to be used in commerce, which is a legal definition, and we'll talk about that in a moment. And then it cannot be confused with an existing mark. Okay. So a mark, let's talk about the first requirement. A mark becomes a trademark if it is distinctive. So what is distinctive? It means you stand out. It means it's distinguished. It's distinct. It's distinguished enough not to be confused with some other mark. And so, the more distinctive a mark is, the more protectable and the greater chance you have a trademark registration with that mark. And so there is a spectrum of distinctiveness. And so this is how we evaluate the strength of your mark to see, can it be protected under trademark law? So when you are on the other scale of the spectrum, when it's generic, that a generic mark is considered a weak mark. So the further you're on that side, it's more of a weak mark. Only strong marks can be protected. So if it's weak, then it's not distinctive and no trademark protection applies. But as we move up the scale, as we move up the spectrum, the stronger the mark becomes. So you have descriptive marks, suggestive marks, and then you have arbitrary marks, which are more stronger marks, but fanciful is at the very end. And so fanciful marks are strong marks. They are distinctive, but they are also protectable. And so, look, I said all this. What is that? What does it mean? Well, I broke it down for you. So, generic marks are marks that are common words, phrases, or name for a product or service. They are generic. So, generic is aspirin, frisbee, and frisbee. So, if you're selling frisbees, frisbee is a generic term. If you're selling aspirin, aspirin is a generic term. Escalator, gasoline, bicycle. Now, aspirin and escalator used to be trademarked. They used to be trademarked, but over time, they lost their trademark rights. And I'll talk a little bit about how you can lose your trademark rights as we go further on in the webinar. Descriptive marks are marks that describe the content. So it describes the content of the product or service, the quality, a function, or a specific characteristic. So for example, descriptive marks are like public storage. It's storage for the public. It's describing what it is. Oh, y'all, frisbee. I done messed up there, but frisbee for frisbee. Best Buy, U.S. News. It's news for the U.S. It's describing what it is. Vision Center. It's a center for where you go get your vision checked out. It's describing. So if it's describing it, then it's a descriptive mark, and it's more on the weak side, meaning that it's a likelihood that trademark protection won't apply. So if you go to apply for a generic mark, you already know you're going to get denied. If you go to apply for a descriptive mark, then chances are maybe, but maybe you won't. Now, suggestive marks is where we're in the middle and we begin to get further to more of a stronger mark. So Burger King, Whirlpool, Jaguar, Netflix, 7-Eleven. So suggestive marks are marks that express or suggest an attribute or feature of the product or service, requiring some thought to its meaning. What does that mean? It means it's a brain teaser. It requires an additional step. So for example, Jaguar, when we think about it, we know Jaguar as an animal, but for cars, it's hinting at the speed of a Jaguar. You see how it's suggesting an attribute. So suggestive marks are marks that are in the middle that may or may not be strong enough to be distinctive and warrant being protected under trademark law. But now we get into two of the strongest types of marks that makes it more likely that you can protect your brand with trademarks, move beyond TM, and get trademark registration. And they are arbitrary and fanciful marks. So arbitrary marks are marks that we know the words, they're in our English dictionary, we understand what they are, but when they're used as a brand for a product or service, they're used as a mark, they are unrelated to the mark or service. So an example would be Amazon. Amazon is a rainforest, but we also know Amazon as what, for 1 day, 2 day delivery to your house. Tide, it's a common known word, but it's being used for detergent. Apple, Snickers, Dove. These words, as they're used as marks, they're unrelated to the product or service. This is what's called an arbitrary mark, but it's a strong mark that, as long as it's distinctive from any other mark in the marketplace, that it has a strong chance of being protected under trademark law. And then you have fanciful words. Fanciful words are made up words. It's made up. And so those marks have they're stronger marks because they didn't exist until you started using it. Google, Adidas, Kodak, Rolex, Pepsi are examples of fanciful marks. All right, so understand this, that weak marks can never be trademarks. So someone asked a question about generic marks. Weak marks, generic marks can never be trademarks. But weak marks are not just generic marks. We talked about the other types of weak marks that you can have. And so the second and third requirement in order for a mark to go from just a brand to a trademark, and it has to meet all 5 of these, is that number 2, it has to be placed on a product and service. And number 3, it has to act as a source identifier. All right. So y'all, I saw this the other day and I giggled, I cracked up laughing. It tickled me, okay? It tickled me because I've seen movies with this man in it and I really don't know his name. I don't know his name. So I'm going to ask you, can you name him? Can you do you know his name? Look, Amani's lap. Look, people's at look, they can't tell you either. Ah, we got somebody. Aaliyah knows his name. You know his name. This is what we're when we talk about marks, brands, being able to identify it. Do you know the source? Can when I see this mark, am I going to be confused about the source? Do I know where it's coming from? And it has, again, it has to be associated with a product or service. And so so when we talk about the mark becoming a trademark, one, it has to be distinctive, it has to be a strong mark. Two, it has to be placed on a product and or service. Three, it has to act as a source identifier. We have to be able to identify the source and know that when I see this mark, I know exactly where it's coming from. Number four, it has to be used in commerce, which is a legal definition, and I'll touch on that. I'll touch on that in a bit. And then number five, it has to be not confused with an existing mark. So when we talk about likelihood of confusion, I believe it was Dion. I think I pronounced your name incorrectly the first time. Mention it. Right there in Coming to America, there was this fictional place called McDowell's. Now, that was in Coming to America in a movie, but somebody actually created McDowell's as a pop-up restaurant. And so we know McDonald's has Big Mac and it's called McDonald's, but McDowell's had Big Mick. And so when we talk about the likelihood of confusion, understand that trademarks protect consumers from confusion in the marketplace. So we want to make sure that consumers know the source when they see that mark so they understand the quality of the goods and services that they're receiving. And so trademark law is about protecting consumers, but trademark law is also about protecting businesses from being able to protect the exclusive rights to their mark. Why? Because if somebody out there in the marketplace is using a mark that is similar to yours, or you're using a mark that's similar to theirs, what happens is that it exposes one, people are confused about the source, but it can redirect potential clients and customers and profits. So the money that would have been coming into your business is now redirected because people are confusing you. And so trademark law also protects your ability to assert your right to protect your brand. It protects your brand reputation and profits. Because if somebody goes to someone else thinking it's you and they have a bad experience, now you're end up with a one-star Google review. You're like, you never even worked with me. Brand confuse the likelihood of confusion. Now, let me say this because people think that likelihood of confusion means that it has to be the same. It's not about it being the same. If it is similar, if it's similar, just similar, whether it's similar in sound, it's similar in name, it's similar in commercial impression, there is a likelihood of confusion that needs to be analyzed. And so just changing a letter or adding letters on the end of your mark does not make it distinctive. Okay, there's still a chance of likelihood of confusion. And so I'll share this. When I was young in my teenage years, we used to go up to New York. My mother and them used to go up to New York, and I would go up there with them. And I don't know how many of you have gone to New York before, but they have these people who hustling. They have these rooms that you can walk up the stairs and you can go to individual rooms and shop around. And so I had me some nice Coach bags, Prada bags. I had some really nice baby fat jeans and everything that I got for $20, $15, $10 because you can negotiate the price. Look, y'all, I got business experience negotiating prices down. But the reality is that some of those products did not come from the legitimate source. And so when you have trademark rights to your brand, we're going to get that, but you have the right to actually stop that infringing behavior, to make sure that there's no likelihood of confusion about the source. So anytime we talk about trademarks, we are always talking about a product or service. You cannot have a trademark if it is not associated with a product or service. And so when we talk about likelihood of confusion, we're not saying likelihood of confusion just out in the ever anything that there can be. We have to limit it to a good or services. And so with trademark law, there are 45 classes of goods and services. Goods are products. Okay. So when I say goods, I'm talking about products. That is number 1 through 34. And then services is 35 to 45. Don't worry about the number so much. Just understand this. I want you to understand this. There are goods and there are services, products and services. And so think about this. Because when we think about classes, I'm like, what does that mean? I want you to remember, like, going the last time you went to the grocery store. You go into the grocery store, and what do you notice, right? They have fruits in one section. Then you may go and they have a whole bread aisle, and there are many different types of breads, but they're all on the bread aisle. Then you go to the back and they have dairy, they have juices, they have meats and seafoods in another section, desserts in one. Then you go over, they have gluten, they have aisles that are separated for each category of what's in the grocery store. The same is true for trademark law. There are different categories within the industry or trades for goods and services, products and services. So, for example, entertainment services has a different classification than legal services. If you are selling clothing, that is a different class than if you are selling medical devices. So, depending on the class that your product or service falls in, depends on how we determine if there's a likelihood of confusion, because trademark rights are not all inclusive. This is why you can have Delta Airlines and Delta Faucets. They are in different aisles under trademark law or different classes. This is why you can have Pandora for jewelry and Pandora for music. And there's no confusion because they are in different, what is called trade channels. They are in different aisles. Okay, so when we think about classes, go back to the grocery store, different aisles. There's no confusion. When I see the mark in the bread aisle and I see the mark in the dairy aisle, I'm not confused because I know they're different. Okay, now when I use that example, understand this, that it's not necessarily translates the same to trademark law, because if you're in food and you see the mark, it still can be confusion because it's in the same channel. The other thing that I want to make note to you is that things that are sold connected to each other. So for example, if you sell hats and someone else sells let's say they sell book bags, chances are people may buy book bags with hats. And so just because it's not in the same class or aisle doesn't mean that may not be an issue. So if it can be sold together in the same trade channel, there still could be a likelihood of confusion. And this is why when we talk about making sure your brand goes from a mark or a brand to a trademark, that likelihood of confusion, seeing if there's anything out there that can be confused with your mark, you have to look at not just the class that your mark or service is in, but also those that are related to it that can be sold together. Okay. So there is no such thing as 100% exclusive rights to your trademark unless you are using the mark for every class. So you have to have all 5 requirements, and one of it is being used in commerce. So use in commerce is a legal definition, and what it means is that there is a bona fide, actual, it's real, it's legit, it's legal use of a trademark in the ordinary course of business, trade. So when you see trade, business, trade is business. And so what that means is it's not just a single or infrequent sale. So you sold one day and that's it, you stop using it. No, it's ongoing use in business. And so for those of you who are familiar with tax law, this is the difference between having a business and a hobby. Because people who have hobbies, you can drop it down. But people who are in business, you are operating a business. It's an ordinary course of business. And so when we talk about use in commerce, it's really you're using it in business. And so use in commerce has to be established before trademark rights can apply to your mark. And so how do we do that? Well, you have to prove that there is a sale or transportation of a mark, of that mark that's on a product, good, or service, whether it's intrastate, meaning within the state, or territorial, interstate, across state borders, or international commerce. Commerce is just exchange of business. And for the second part, it's commerce that Congress can regulate. So, excuse me, you either have to show a sale or transportation of a product or service either within the state or outside of the state. Now, I'm talking about trademarks in general here, and you're going to understand in just a moment why. So, for example, if you are in Maryland and you do business in Maryland, well, guess what? You have a trademark in Maryland. But if you have a trademark that you are, excuse me, if you have a mark that you're using in Maryland and it's only in Maryland, then you have possibly trademark rights statewide in Maryland. But if you have a mark that is being used in Maryland, but you're also transporting it to Virginia, you're transporting it to New York, then guess what? Now you have gone beyond state borders and you fall within the jurisdiction of the federal government. So where you do commerce, where you do business, determines the scope of your trademark rights. So trademark rights are based on use. No use, no rights. No use, no rights. And so again, you have to have all of the five requirements in order for your brand or mark to go from just a brand to have a trademark protection and be eligible as a trademark. So, all right, y'all, wake up, wake up, wake up. I want you to stand up wherever you are, as long as you're not driving. Stand up. I want you to stretch. I want you to shake out those legs, move and wiggle around. Come on, get up, get up, get up, get up, get up. Move around, woo, because we got to get ready for our challenge. Woo, woo, woo. Y'all ready? If you're ready, you ready, you ready. You're just about to stand. Look, I know it's late. We had a long day, right? We had a long, long day. Get up, get up, get up. If you're ready, put ready in the chat. Ready, ready, ready. Are you ready? I'm excited. Ready, 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 ready. All right, y'all. Woo! All right. I'm asking you ready. And if you ain't ready, you better get ready. Excuse me. All right, y'all ready? All right, so get ready for the Beyond TM Trademark Challenge, y'all. Come on. So here is the challenge, all right? You have 30 seconds to find as many items as you can that have the following marks in them. I'm not going to show you the marks yet because I learned my lesson. People were getting the marks ready and getting things before I even said go. So I learned my lesson. Okay, so you're going to have 30 seconds to find as many items as you can that has these marks on them. The person who has the most marks wins. Not the most items, the most marks, okay? So most marks win, not the most items. Now, at the end of 30 seconds, I'm telling you this in advance. Don't worry about this just yet. But at the end of 30 seconds, what I'm going to have you do, so you're going to have to bring all your items with you. You got to grab all your items. Grab all your items. You want to grab all your items, and what you're going to do is you're going to take a photo of your items, and then you're going to post it online with the hashtag Beyond TM Webinar, and then you're going to tag my law firm. I have instructions for you. You don't have to remember this. It's going to come on the slide when we get there, okay? But for the sake of the challenge, you're going to have 30 seconds to find as many items that has find the most marks. All right. Are you ready? Any questions? You ready? Set. Alexa, set a 35-second timer.
35 seconds, starting now.
Go. You have to find as many items with these marks on them, these symbols. Go, 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 y'all. 30 seconds. Woo, woo. Woo, woo. Go, 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 go. Do, 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 do. Do, 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 do. Talk, do, 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 do. Oh. All right. So for those of you who are like, where do I find these items? I'm going to give you a tip. Oh, it's already, the timer is up, y'all. Time up. Come back. Let me know when you're back. Come back. Alexa off. All right. So stop. Challenge is over. 30 seconds is over, y'all. 30 seconds is over. All right, so let's find out who our winner is. Who is our winner? So first and foremost, what I want you to do is I want you to take a photo now. Take a photo right now. Because we're going to need this for verification purposes. Take a photo of all of your items that you grabbed, okay? Now, once you have your items, I want you to count all of the symbols you see on your items. So every TM is 1, every SM is 2, every TM is a 1, every SM counts as 1, every R counts as 1. Count them all up to count how many do you have. And then what I want you to do is I want you to drop your name and your number in the chat. Drop your name and number in the chat. And let's see who is our winner. Who has the most symbols? Not the most items, the symbols. We're counting the symbols, not the items. So let's see. All right, let's see. And everybody, let's see. I'm looking at the chat for your answers. Can it be for the same name? So if you have 2 items and they have different symbols, yes. So every time, just count the symbol. Every time you see a symbol, that counts as 1. It doesn't matter if it's the item belongs to the same brand. As long as you see a symbol, it counts as 1. Okay, Mona has 5. Anybody else? Anybody else? All right, Mona, you might be the winner by default. Nobody adds anything in here. Woo, Sarah got 26. Oh, man. Okay. Anybody else? Come on, y'all. All right. You might be still counting, and that's okay. Look, this is why we have a verification process. I don't know how many of you have ever taught. I've worked with youth for more than half of my life. So I trust that your math is good, but we're going to verify, okay? We're going to verify. That's why the photo is important. So Mona has 5, Sarah has 26. All right, I'm going to give about 10 seconds for anybody else it did go by very quick. I'm going to give 10 seconds for anybody else to count up and add them in the chat, okay? You submitting it in the chat and then posting it when we get there, that is your submission, okay? But right now, it looked like Sarah might be in the lead unless somebody can beat Sarah. And then by default, if nobody can beat 5, then Mona is the runner-up. All right, 5, 4. Any more submissions? 3, 2, and I'm trying to give somebody. All right, 1. All right. So whether you submit it or not, this is what I would like for you to do. I want you to take your photo of the items that you collected, and I want you to post it on Facebook and Instagram, and I want you to post it now. So post it right now. And I want you to add in your caption that I took the trademark challenge and put your number. So if it was 5, put 5. If it was 26, put 26. And then use the hashtag #BeyondTMWebinar. #BeyondTMWebinar. And then tag Legacy Legal CF, okay? This is how I can go on. I can check, look at your photo, see what you got. Now, if you're not on social media, because some people are not, then you can text it to the number below and make sure you put your name and your number, okay? This is your submission. But because of Sarah and Mona who participated, You participated. This next step is your official submission. So once I see that, I can verify. Here is what you won, Sarah. Here is what you won, Sarah, because you are our number one. You won a free trademark consultation with me. A free trademark consultation with me. And so after this webinar, look, I told you, Dion, you gotta participate. You gotta participate now. You want a free trademark consultation, and so what that includes, and you'll learn a little bit about what that includes later. But I will message you afterwards so that you'll get the link to set that up. Okay. Now, because I came in with the intention to also reward the runner up, because nobody put in the chat that they beat 5, then Mona, you also won a free trademark legal consultation. So it wasn't just for the runner up, it was also for the second runner up as well. So I will I know your name, I have your email address, so I will follow up with you probably tomorrow so that you'll have that and you can schedule. Now, for everybody that's here, don't worry. I have a gift for you towards the end, so just stay with me. But we're going to keep it moving with our the rest of our webinar, okay? So the reason why I had you do that, I don't believe in doing unnecessary stuff, right? So we needed a stretch break, but also it's because I want you to get familiar with looking at these different symbols because there are different types of trademarks. And so a trademark can exist with or without registration. And there are 3 types of trademarks. So you have common law trademarks, state registered trademarks, and federal registered trademarks. So what's the difference between this? A common law trademark is a trademark that exists at common law. So remember, we went through the 5 rules that you have to meet all of those requirements in order for your mark to be a trademark. Once it's a trademark, depending on how you're using the mark, depends on what type of trademark it is. And so common law trademarks are protection that is applied to trademarks that exist at common law. It's an unregistered trademark, and so it gets trademark protection. But then you can register your trademark either at the state level or the federal level. So state registered trademarks are trademarks that are protected under state law. And then you have federal registered trademarks, which are protected under federal law. And so it's not, if you have a federal registered trademark, it's not that it's not protected under state law or common law, because if you notice some of the items that you grab is that they have the R, but they also have TM, because not every part of your brand will you register as a trademark. And so you can have many different types of trademarks even within if you have products, even within one product or within your service. And so one thing to understand is that each type of trademark has geographical restrictions to its protection, meaning that the type of trademark you have and depending on where you use it depends on the protection that applies to it. So let me go back. So common law trademarks and state registered trademarks are limited to where you actually use them. So if you are in Texas and you use your mark in Texas, but you never go beyond Texas, or your trademark protection is limited to Texas as long as you have a trademark. If you're in Texas, but you go to Nevada and you also go into Montana, then now you have trademark protection in all 3 of those states. You see how that works? But if you decide to register your trademark, now you have protection nationwide. But remember, trademark protection is not for every good or service. It's limited to the class that your good or services is in, okay? So how do we go beyond TM? How do we go beyond an unregistered trademark? How do we go beyond a common law trademark? Well, we do that. Understand that TM is the symbol for unregistered trademarks. So unregistered trademarks can be protected as a trademark, but again, their reach of protection may be limited to the geographic regions where the mark is used. So you can only use TM for common law trademarks and for state registered trademarks. But to go beyond that, you got to get on the road to R. You have to get on the road to R. So to go beyond TM, you have to get on the road to R. So we started out talking about road trips and journeys. And so going beyond TM is taking the journey from TM to R by filing a trademark application for nationwide exclusive trademark rights. And so the reality is that your journey starts in the branding process. When you're branding, that's where you start. But that's where the mark starts. Excuse me. When you are in the branding process, that's where your mark starts. But as you begin to journey, depending on the road you take, your real start when you go from TM to ART starts at the USPTO database. And so I said database, goodness, the USPTO office. And so the journey begins there. But understand that some applications will make it to their destination of R, which is registered, and others get stopped and derailed along the way. So they never go beyond TM. And we know this all the time. People get on the road, they have accidents, they never make it to their destination. But for your trademark, the same can be true. And so the road to R. This is an overview of the federal trademark registration process. Y'all, I worked hard. Yes, Mona, I will give you that number in just a moment. I worked hard on this, y'all, working through. I've been working on this for a minute. And this is, I told you I have a teaching background. So I'm always trying to find a way to bring it home for people to understand. And so the road to R, right? We drive, we understand road symbols. And so the first step in the process you ever before you ever start driving, you have to do a safety inspection check. And so what do I mean by that? Well, you want to make sure that the vehicle that you're in is actually safe to get you to your destination. And so you conduct what is called a trademark legal clearance search. That is the first step that we do. And so for those of you who are the winners of our challenge, a trademark legal clearance search, what it does, and that's what we'll do a partial of that in the consultation, is it looks to see what is all out there in the universe of trademarks that can be a potential roadblock to your registration that could hold up you getting to your destination. And so we flag it, but it's also an evaluation of, can your mark actually be successful at registration? Now, we can't guarantee it, but we can look and see, is there something out there that could potentially block you? And so as you conduct the search, then you're either going to get the red light, if the engine check light come on, check oil, you don't get on the road. Hopefully you don't get on the road, right? You go to someplace, AutoZone or someplace else to get your oil change. You do all the safety mechanisms to prepare yourself to move forward, or your car may not start, and that means you're not getting on the road. And so in the trademark legal clearance search, you're either going to find out whether this is the end, or you have the green light to move forward, or you can move forward, but you got to move forward with caution. Okay. And so as you begin the journey, you get in the car, you start driving, your first stop is going to be to file your trademark application. And so I want you to remember, I want you to think back to driving. And you know how some highways, they have the express route, and then they have the scenic route that can, they're going the same direction, but sometimes they have different ways that you can take a different, you can turn off more on the scenic route than you can the express route. This is an example of what happens for the trademark application. And so when you file your trademark application, you have two options. You can file it as a current use or intent to use. Current use is a 1A application. Intent to use is a 1B application. You don't choose this. It's automatically set up. So if you're currently using your mark in business, it's automatically a 1A application. But if you have you're not using it, but you have a good faith intent to use it in the near future, then that is a 1B application. So 1A, and you have to be using it for that class, that category of product or services. But if you're not, then you're in the 1B category. So depending on the application you choose depends on your journey. Now, both applications journey up until the same route up until a certain point. So the next stop for both applications is once you file it, your application is then assigned to an examining attorney, and it's assigned for review. So this process is estimated to take between 6 to 12 months. It really just depends on the attorney and their workload and how many applications have been filed. This stop is kind of like border control. So before you can go from Canada to the US, border control will stop you and they will evaluate your documents, look at your vehicle, everything. It's a stop. You cannot move forward until you pass inspection. The same is true for your application. And so what's happening is they're going to, once it's assigned to them, they're going to have a time where they inspect your application. And if they find any flaws with it or any issues, what's going to happen is you're going to get to stop number 3, and you're going to receive an office action. An office action is an official letter basically telling you, hey, we found these inspection issues. These are some issues wrong with your application, wrong with your trademark. And because of this, you have to fix it before you can move on. So if you don't fix it, you can't move on. And you have an opportunity to respond to the office action. And so in this process, you have 3 months to respond to an office action. If you don't respond, your application can be abandoned, meaning you didn't paid all that money and the application is gone. Now, you can pay and request extensions, more time to file, and that's 3 months. Now, if you either your application was good, there were no issues with it, or you successfully defended your application in responding to an office action, you move on to stop number 4, which is publication. And so in publication, what happens is they're going to post a notice, publish it in the Gazette. That's their official publication. And they're going to do that for 30 days. Now, the reason why they do that is because they're giving other people the opportunity to, if your trademark application goes through and it might infringe on their trademark rights, they're giving them the opportunity to say, I object. So look, I love A Different World. That's one of my favorite shows. And I love the part where Dwayne showed up at Whitley's wedding and with Byron and said, he objected to the wedding. And so this is the same is true for the notice of opposition. During that 30-day period, people who feel like your mark will infringe on their rights can object to you going forward in the process. And so if there is a opposition, somebody objects, then you have a pit stop. And so in that pit stop, now you get taken out of the process, and now you got to go to battle, because we're in a litigation zone now. And so that's a TTAB hearing. So now this is where you got to fight, because if you don't win this, you might lose the ability to register your mark as a trademark and any rights to that mark at all, because somebody is opposing you. And so remember that number in the beginning, I said, what was the number you invested in your brand? If you lose at this stage, that means you got to start all over. You got to invest all over again. Okay. But if you pass the publication stage, then you move to stop, depending on what route you took. So remember in the beginning, I said there are 2 types of applications and you could take 2 different routes: express or the scenic route. So if you took the scenic route, meaning the 1B, you're not using your mark in business just yet, then you are in the scenic route, which means your next stop is stop number 5. This is only for in a 1B applications only. And so what happens is, remember, no trademark protection applies unless you show use. You have to be using the mark. So if you're not using it, stop number 5 says you got to show us use before we let you move on. So this is where the trademark office will issue what's called a notice of allowance. And it basically is for you to submit, respond, and prove that you are using your mark. So if you're not using your mark, then you may request an extension, more time to be able to show use use so that trademark protection can apply. And so when you are at this step, typically what happens is you're almost guaranteed registration. You just have to prove that you're using the mark. And so you have 6 months to submit that proof. If you don't submit that proof, the road can end for you, and that's it. Okay. But instead of losing your trademark rights, it just means that you have to start the process all over again, because the registration fee is non-refundable. So you have to go through that process all over again to apply again. But if you prove use, you are successful at doing that, or if you apply as a 1A, meaning you're already using your trademark in business, you're on the express route, then you move all the way to destination or reach, meaning your trademark application has been approved and you have a registered trademark. You have gone beyond TM and now you have the right to use the R. And so here is where people think that the end of the process is. No, it does not, because trademark rights are based on use, not registration. And so future stops, these are future things you have to do, right? When you have a car and you're going on road trips, you have to do ongoing maintenance to keep your car in good shape. The same is true for your trademark. And so there are maintenance and renewal filings that are required. And so your first filing will be between year 5 and 6 after your trademark has been approved. The second one will be between year 9 and 10 after your trademark has been registered. After you get to that second filing, it's every 10 years. So each time you have to do a filing, you have to show them you're still using your trademark in business for the classes that you registered for. And so the total trip time between when you start the process in filing your application until you get trademark registration is between 12 to 18 months, but it could be longer than that. Some people have been waiting 3 years just because things happen during the journey. Now, the application fee per application per one class is $350. $350. So if you want to apply for protection in 2 classes, then that's $700. Okay, that's just the USPTO fees. Now, what are the benefits of having a federal registered trademark? Well, first and foremost, it's exclusive nationwide rights to use your trademark in the US in the classes that you registered in. It also helps you establish legal ownership and a strong foundation for any legal action. So if you have a common law, a TM trademark, you have to demonstrate that you actually have the rights to stop someone from using it in maybe another state. But when you have a registered trademark, it's nationwide because it's under federal jurisdiction. So it's already proven that you have the right to stop someone no matter what state that you're actually operating in. The next benefit is brand recognition and trust amongst consumers, clients, and customers. Because when people see the R, they see that you are a legitimate business. You're not a scam. How many of us know, like all of the scams taking place, people are a little iffy about coaches and investing in folks because there are people who are losing their jobs and they're starting businesses, but not everybody is doing legit business. Not everybody is integral in business. And so it leaves a bad taste in people's mouths and they get a little funny and stingy with spending money. Although you are good, they don't know that. And so what happens is that when you have the R, it leverages your brand to show that you are someone that takes business serious and you invested. It also helps you create a valuable business asset. Intellectual property, like your trademarks, are assets of your business, and it can increase the value of your business, especially if you're thinking about selling it or licensing things. But you can also use your trademark as collateral. Another benefit is registration. So if you want to go global and go to another country, you can also use your US trademark registration as an opportunity to secure trademark rights in another country. And so I didn't mention this, but look, trademark rights in the US are based on US law. You do not have brand protection in another country unless you abide by that country's laws and apply. Okay, so when we talk about brand protection here, we're talking about just the United States. And then another benefit is you have the right to use the R symbol. So the R symbol is just for a registered trademark. Now, for those of you who have products, depending on, what happens in the government, you can also have the government stop infringing products from coming across the border because you have a federal trademark. Okay. So for those of you who want a trademark legal clearance search, I want to talk to you now about trademarking with legacy. And then stay tuned because I have some bonus materials that I'm going to give you, some mistakes to avoid in the branding process and building your trademark, as well as a free gift towards the end. And I'm going to open it up for questions in just a moment. And so trademarking with legacy, let us guide you safely to your destination. Look, y'all, I've seen two spelling errors, and that was not my intention, y'all. Not my intention at all. And so my poor ass, I don't know how I did that, but we gonna get you there safely, okay? And so we have two options. The first is the Launch with Peace of Mind Consultation. And so for those of you who won the trademark legal consultation, this is it. And so what it is it's a 30-minute trademark legal consultation. And what we do is we do a preliminary trademark search. So it's not a comprehensive search where we're searching everything out there in the universe, but we're looking just at the USPTO database. We're looking just at federal trademarks. And so what we do is we evaluate the strength of your mark. So some of you are branding, you're getting ready to launch, and you want to know, is my mark strong enough to be a trademark? But then you may wonder, okay, is it possible that I might launch and be infringing on someone else's trademark? Well, this is where in this consultation, we begin to do that work. And you'll get an assessment of the strength of your mark, the likelihood that if you pursue registration, whether or not you will be successful or not. So there's a preliminary assessment, a risk assessment, and an analysis of whether or not you should rebrand or go ahead and launch. And so the question that's asked during this consultation is not whether or not you can trademark your brand, but it's whether you can launch it at some type of level of safety based on the USPTO results. Okay. Again, it's not a comprehensive search. There's still some risk involved unless we do a comprehensive search, but at least you'll launch with peace of mind. And this is the evaluation. So you'll know how strong your mark is, whether it's a trademark or it's not. And so the investment for this consultation starts at $150 because it depends on how many marks you have. Okay. But it starts at $150. So if you have one mark that you want to look at, then it's $150. And then once you do the consultation, this is the first step in the process. Everybody starts at this step. The fee can be applied towards the trademark registration package. So if you do the consultation, even if you didn't win, and you pay the $150, you can apply that to the trademark registration package if you decide to move forward, but you have to do that within a 14-day window. So 14 days after our consultation, you'll have 14 days to decide whether you want to move forward or not. So if you decide to move forward with trademark registration, then our standard trademark package, this is what it includes. It includes a comprehensive legal clearance search. So we're searching everything. Every single thing that can be searched for the United States, we're searching to make sure not just about can you register your trademark and are there any conflicting marks that would act as a roadblock to your registration, but we're also spotting potential flags, right? Getting ready that if the USPTO office, the examining attorney says this is an issue, we've already spotted it in our search. Now, if our first search is a dud, it turns out you got to rebrand. It's just not working. Then built in complimentary, we'll give you another search for free if the first search fails. You'll also get an opinion letter. And so this is my risk analysis. That's red light, stop, yellow light, sometimes I do an orange light, and then red light, green light. So you can hit red light, a green light, yellow light, or green light. Green light means it looks like we're good to go, meaning proceed forward with registration. Orange is like, there's some risk. Yellow is proceed with caution, but the choice to do so and move forward is always in your hands. Okay. You also get a 30-minute consultation. So we'll talk about the opinion letter. We'll talk about next steps, but you get that built into the package. Next, we prepare and file your trademark application. And so the filing fee for one mark in one class is included in our package. And if you want to add additional classes or you want to register different marks, I've had clients who wanted to do that as well, then that fee is additional. That's an extra fee, but we prorate the our fees, our legal fees, but you have to pay the USPTO fees. Okay, so you'll know that when you schedule to talk about that. Also included is office action responses. So all responses to office actions are included, as well as the trademark registration certificate. So once you get registered, your trademark is registered approved, you get the certificate and you receive our maintaining your trademark after registration guide. So we don't leave you hanging. We make sure you understand how to keep your your trademark registration alive and moving so you don't lose it like so many have in the past. And so the investment for our trademark package is $2,500. So it's $2,500, but we don't charge that all up front. Now you absolutely can pay that up front and that's all there. But the initial fee to get started is $1,500. And then the remaining balance is paid on a payment plan. So the reason why 1,500 is the initial investment is because what I found is that when I build in 3 stages, the first stage just billing for the comprehensive search, and then the second stage for the application, is that when clients didn't have the money for the second part, now we're stalled, and the search is only good for a certain amount of time. So the initial investment is $1,500 to get started with. That includes filing your trademark application. Okay, so that at least ensures that we get you moving in the process to get you started. Now, because you are here and you stayed, y'all stayed with me to the end. Y'all stayed with me. Y'all stayed. I got something special for you. And so because you stayed to the end, because you've been here, because you've been invested, if you are looking to trademark and you want to trademark with legacy with me, here is what is available to you. If you decide to trademark by May 1st, instead of paying $2,500, the entire package will be $2,000. So you can get the package for $2,000. Okay. If you decide to trademark by June 1st, look, I know we are all at different stages of our business, different stages in finances, okay? So I'm sensitive to that for my clients as well as the other folks with everything going on in the nation. And so I know some people have already told me they got to get their money together. That's fine. So if you trademark by June 1st, I knock off $300. So you can start the process for $2,200. Now, one of the things that I want to make note of is that many people have seen other prices of other trademark attorneys. It happens. And so you may see that a price is less. I want you to be mindful, whether you decide to trademark with me or not, is that oftentimes what's not included is the responses to office actions. And so they will charge you more for that because often office action responses are literally legal briefs. They're legal responses. We're not responding with nice English words. We're responding with law and case law to back up our responses. This is a legal process. And so we include all of that in there. We don't haggle you with price. It's included. Other people will charge you $500 per hour. I've seen it. And what I've noticed is that because you don't know what it includes, it's like a bait and switch. So you'll get started and not realize that there's hidden prices up front. My law firm is flat fee. We don't hide the prices from our clients. You know exactly what you're going to pay before you pay it. And if something is going to be more, we'll let you know that up front. We don't hide it. We don't nickel and dime our clients. We do business with excellence and integrity. And so be mindful, even if you are like, I don't know, just be mindful. Pay attention if office actions are included or not. Okay. Now, if you decide to take advantage of the Beyond TM gifts because you're here and you do so by January 1st or June 1st, what's also included is complimentary trademark monitoring service for 1 year. So after you go through the process, your trademark is registered, we automatically enroll you in our watch program. And so for 1 year, what we do is we watch everything in the United States for potential infringement. We watch to see, okay, is anybody registering? Is anybody trying to infringe on your mark? And that is a part of our watch service, okay? And there's some other services involved in that as well. But you get that complimentary when you take advantage of the gifts by you being here. So when you when you go to schedule your initial discovery call, you want to include in the comments, I was a part of the Beyond TM webinar, the Beyond TM webinar. That way I know, okay, when you do your trademark consultation, which is the first step in the process, now I know whether or not you take advantage of the 14-day window to apply it to the package or not. You still lock in this rate, okay? As long as you meet the deadlines. Now, to get started, all you have to do is schedule a discovery call. Our discovery calls are free because we have to get some information from you first before we move on with the process. And so you can do that through our website at legacylegalconsult.com. And for those of you who, you're not going to remember this, you can take a screenshot of this. Go ahead and take a screenshot. You can go ahead and take a screenshot of this, all right? So you'll have it. All right, so do I have any questions? So do you have any questions about the trademark package, whether it's the consultation or the package? And then after questions about this, I'm going to open it up for questions in general about the webinar. But just right now, are there any questions about our trademark packages, whether it's the launch with Peace of Mind, the trademark consultation, or our trademark registration package? Check the chat. Any questions whatsoever? Okay. I'm not seeing anything. I'm not seeing anything. All right, y'all, get ready for your questions. Queue up your questions. Queue up your questions, y'all. Queue up your questions. Queue up your questions. I got some questions that were submitted prior, but get ready for your questions, your general questions, everything that you saved, because we're about to move to Q&A now. All right, so if there are no questions about the trademark package, again, for those of you who are interested, you're ready to get started, you can, or maybe you need some time. Go ahead, make sure you save our website to schedule a call, or you can get scheduled now. And you're on the email list, so you'll receive emails. Do you offer custom consultations regarding trademarking? Absolutely. One thing about owning my own law firm is that I get to create things that my clients need. So if you need something that's customized, we can do that. And that's why the discovery call is the first step in the process. And it's free because until I know what you need, then I don't, until I know what you need, I don't know exactly what legal service to provide you. So we start with clarity first, getting clear on what your trademark needs are, and then we give you what the legal package is. Because what I found is that when you're not clear, it costs you more money because you can end up getting something that you actually didn't need. So we start with clarity during the discovery call, then we move on to legal services and things like that. And I customize for my clients all the time. That's the benefit of being a boss, right? All right. Questions. Let's open it up to questions. Okay. So as you are preparing your questions, and I know we're at time, I'm going to ask you for 15 additional minutes, maybe 20, because I want to get through all of the questions. So as you are preparing your questions, you can put them in the chat now, but some of you submitted questions when you registered. So for example, Sarah, Sarah, who has her business is Your Nutrition Mission in Arizona. She asks, if and when should I trademark my business? Not sure if this is related, but do I need to register my business with my state? So anytime you are doing business in a state, you need to register your business. Now some states allow for you to do business as a sole proprietor, and that's okay. But if you are starting to do starting to sell products and services, you want legal protection, it is best for you to register your business. So if your state allows for you to register as a sole proprietor, do that. But if your state doesn't permit that, if you need legal protection, meaning that you want to make sure that if anybody sues you, your LLC provides you with liability protection, then register for an LLC. The one thing that I would tell you, like I tell everyone that I talk to when I tell them this, is make sure you know the cost to do it. Meaning, is there an annual cost to have your LLC in that state? You want to make sure that you have that. And so if you're not ready to launch, that's okay if you start as a sole proprietor and then move up to an LLC. But make sure that if you decide later on to get an LLC this year, please make sure you understand what the annual fee is to have an LLC in your state in Arizona. But chances are, if there is an annual fee and you get to quarter 4, just wait until the new year, because in quarter 4, you want to, If you start a business in Q4, then come around the next year, you have to pay taxes for this year in next year. So rather than paying taxes at the end of the year, just finish the year out and start in the next year. That way it gives you enough time to get revenue up, get more money in their marketing, get your business off the ground, and then money flowing in so that you can pay that fee. Okay. Um, no problem. And then when should I trademark my business? That answer is in the bonus material. So we're going to get to the bonus materials and I'm going to answer that question. Doris of DD3 in Maryland said, just starting a business around my brand. She has it registered in the state and EIN number and just want to protect the name. So if you just want to protect the name, then schedule a call with Legacy Legal and Consult, and we'll talk about your name, get you set up with a trademark consultation so we can evaluate the strength of your mark to see, is it a trademark? And if it is a trademark, whether or not you should move forward with trademarking. Now, one of the things that I am intentional about in my business is strategy. Strategy. And so you may come in with an idea of what you want to trademark, but it's not advantageous to your business. So rather than wasting your money, we're going to identify what are the key aspects that really you should protect in your brand in connection with the vision of your business. So for example, I had a client who wanted a part of their vision strategy is to expand globally into particular countries within the next 10 years. Well, now we can identify what to actually protect once we know what the business strategy and vision is, okay? Monica of Blueprint for Style in Maryland says, if we believe we have a TM already in process, a trademark, how can we find out its status and if it needs to be redone, resubmitted? You do a search of the USPTO database, and I do apologize, Monica, because I actually had it in my heart to do the search for you to find out. Okay. It's a really quick search. So whatever your mark is, if you actually filed a trademark registration with the USPTO, then just search for that mark and see. Because I had it in my heart, I'm going to honor what I originally intended to do. So Monica, if you are watching the replay, then just shoot me an email. Now, I'm going to put some time parameters in this, okay? So shoot me an email by the end of April. The end of April is my deadline for this. And I'll do a quick search. Just tell me what the mark is that you believe you have a TM for, a trademark for, and then I'll do a quick search to see if it's there or not. That's all it is. It's going to show if it's there, if it's abandoned or not. Okay. Mona says, I did a general search for what I'm looking for to trademark, and someone has a Facebook group with the name, but it is not listed in the general USPTO. Is it frowned upon moving forward knowing that someone is using the name? So if somebody is using the name already, then they're using it in commerce. And so if all of the Fab Five requirements are there and they're using it, chances are they have common law trademark rights, which means that if you move forward, then you're potentially infringing on their trademark rights. This is where you get into cease and desist. This is where you get into lawsuits. But also, if you move forward with registration, then what happens is that they can block your registration. Now, another thing that I want to emphasize here is that trademarks are based on use. So whoever has prior use rights, the earliest date of use is the one who has the trademark right. So if they've been using it before you, their rights will stand against yours. So you may want to rebrand. And this is why that consultation, the search is so important, because before you launch, you can just rebrand and save yourself all of that money. Remember the beginning when I asked you the dollar amount? You can save yourself all that money and the headache and the pain of finding out too late. There are people who found out in year 10 of business that their podcast was already trademarked and they had no idea. And now they have to rebrand. Can you imagine doing all that work to build up a brand? And then you got to tell somebody, you got to get rid of I'm talking about you have to take down every podcast episode, every flyer, everything that has that mark on it. You got to take it down. You cannot use it anymore. That's a lot, okay? Nicole King, the librarian in Maryland, she asked, my business name was created in 2023 during a business course. There are people who know of it, and I have a single customer to validate the concept. I'm officially promoting it to get clients this month. Should I get the name protected first? It really depends on whether or not that is strategic for your business. So you don't have to protect everything in your business, including your business name. You want to be intentional about what you protect. Now, again, this depends on how you are doing business. So it depends on how you're marketing. I have a business that I don't market that business. I don't market the business name. I market the brand name. So the brand name, there's a trademark application for it, but not the business name. So it really depends on a number of factors. And so if you are interested, you can schedule for a trademark consultation and we can talk about that. Okay. Carla, the wedding communication studio in Texas, asks, would love to learn about trademarking from a nonprofit standpoint. Would also like to learn about trademarking generic terms or new language. So we talked about generic terms. Weak marks like generic terms don't have trademark protection. And so again, we talked about this. Nonprofits can have a trademark. You just have to make sure that you're abiding by the Fab Five rules. You have to meet all of the requirements, but you can have a trademark even as a nonprofit. And then new language, we talked about new language. If it's a new language term, meaning it's a new word, it's a made up word, that has the strongest protection as a fanciful mark. Giovanni, Beacon Public Health in Maryland said, what's the process to complete a trademark application? Well, this webinar wasn't about wasn't about teaching you how to do the trademark application, but there are many steps to it. So when we get to the trademark application, just the application, first and foremost, you want to do a trademark legal clearance search because you want to make sure that you're not submitting an application for something for a mark that's already trademarked or will be confused with another trademark, or you don't want to waste your money going through the process. There's also important information that you need to collect and understand from a legal standpoint in order to file your trademark application. That includes understanding the difference between first use date and first use in commerce date. It also includes, if depending on what application you're going to file, whether it's 1A or 1B. Remember, 1A, you're already using it. 1B, you intend to use it in the near future. Depending on the application you choose, you want to make sure that you have you're already using it, you have your proper proof, okay? If you can't show and demonstrate proof, you may not move forward in that application process. And so there are other things that you want to make sure, and there are mistakes that you want to avoid in the application process that I see people make, and like, oh, you just don't want to do that. Another thing you want to be aware of is that the trademark office changed their fees in January, and so they added fees that kind of act as a penalizer. So when you are doing your description of product and services, if you want to avoid their fees for writing in your own descriptions, then what you want to do is you want to use the descriptions that they already have. Okay. The best thing you can do is, if you are, because there's someone else, Larissa, the Larissa of Rofi, I hope I'm saying that right. Rofi MD Maryland said, if I do not have sufficient funds for a trademark yet, what can I use? For example, an NDA for business that I have just started. We're going to talk about that in the bonus materials in just a moment. But if you don't have the money to hire an attorney, like, it's just not there. It's just the reality of it. If the money ain't there, it ain't there. You can't make money appear, without, certain things. But you can't make money just appear. And so if the money is not there, then you have the option of filing yourself. But this is where I say you need to understand the nuances of the application process, understand the legal definitions. The USPTO has webinars to help you learn how to do a search if you're trying to learn how to do it yourself. And there are other folks who have classes that will teach you. I have, and I intend to have a class in the future, but right now that's not something I'm offering, just because I want to make sure that when I do it, I can do it with excellence, okay? And so, Larissa, I'm going to answer your question in just a moment in the bonus materials. All right. I think I answered all the questions. All right. So When should I trademark? This is a question that many people have. When should I trademark? And so, because it's a common question, the answer is it depends. It really, really depends. And so, this is like the chicken and the egg. What comes first, the egg or the chicken? And so, it's really about trademark timing. And it's also about the unique needs and circumstances of your business. And so, you have the option of trademarking before you launch, meaning that you file a 1B application to lock in your trademark rights, or you can file after you launch. You're already using it in business, so trademark rights have already attached itself if you met all the 5 FAB requirements. And so you can file a 1A application. Now, let me say this, okay? Because remember, trademark protection doesn't apply until you properly use it. So you have to be using it, meaning that when you're in the branding process, when you're in the creative process, there is no protection for your brand under trademark law. There's no protection. So someone can steal your brand in that process, and there's nothing you can do about it. And so, depending on your unique needs of your business, what you're doing strategically, if you're about to license, if you're about to expand, creating franchises, doing affiliate marketing, it really depends on what the circumstances are. It depends on the strategy for brand protection. Sometimes you can trademark after you launch, and it's completely fine. You'll be okay because you're establishing your rights. But sometimes you need to secure your brand before you launch. I went through a rebrand. I started my rebrand process last summer for my personal brand. And when I would share in a protected environment what my new brand was, the reaction that I got from people who were excited about it told me instantly, don't tell nobody else. Don't tell nobody else. Don't put this on Facebook. Don't tell nobody else until you file that trademark application. Because trademark law would not have protected my brand if somebody decided to go use my stuff. Okay. So remember, trademark rights are based on proper use and distinctiveness. It cannot be generic, it has to be distinctive. And you can lose your trademark rights. So, mistakes that prevent you from protecting your brand with trademarks are branding with weak marks. If you have a weak mark, there's no trademark protection. If you don't use your mark correctly, it's improper use. You can't demonstrate proper use, meaning the mark can't just be it can't just be like a decorative. It has to be used as a source identifier. And then for those of you who maybe you're going to file your own application, I'll put this in here. I'll put this in here. Put this in here. If you, for example, a t-shirt business, a mark on your t-shirt is not protected. This is why proper use is important. But if you put the mark on the tag, that's protected. If you put the mark on, let's say the mark on a packaging, that's protected. For those of you who have service-based businesses, you can't put a mark on your service because it's a service. So where do you put the mark? You put the mark on your website where services are sold. You have to demonstrate proper use of your mark in connection to the products or services. The other thing, which I just mentioned, was revealing your brand, revealing your mark, trademark before you protect it. So revealing your mark, because until trademark protection applies, it's left exposed. And so just like I believe it was Larissa had a question, I'm going to give you some brand protection strategies that you can use beyond trademarks. And then another mistake you want to avoid is registering for a federal trademark before you lock in your brand. So oftentimes what happens is we start business, we're testing the market out, we're not sure. And this is why, depending on like when to market, if you're not sure about the market, you're not sure if this is the name that's going to have traction, then don't trademark your brand because you're going to waste your money, because you're going to end up changing it. Or you get a design. And I've seen this happen. People register a logo and they have things in the logo and then they change their logo. Well, now because you changed it and the way that you registered your application, your trademark registration no longer protects the new logo. So only the mark as it is registered, is protected. So if you're trying to lock in the exact design, color, and style, then any future changes are not going to be protected under that registration. This is why it is recommended that when you are applying for a trademark, don't try to do the most basic one that you can do. The most basic, whether it's just the logo or whether it's just the name, making sure that you're not trying to do a particular style or particular color, because if you lock that in, then you have to keep that color or you lose your trademark rights. Okay. And then you also can, mistake you want to avoid if you want to protect your brand with trademarks is failing to enforce your trademark rights. So for example, I mentioned escalator. Otis, I believe it's Otis Elevator Company. They used to have a trademark for escalator. And I think it was escalator as well. Because escalator became commonly used, they lost the rights to that trademark. Aspirin is another as well. And so there are companies that are going through the process of trying to keep their brand protected with their trademarks. How many of you see a box of tissue and you say Kleenex? Kleenex is not what the name of that tissue is. It's a brand. And so oftentimes you may have to do some education of the public. Xerox is an example. Xerox is in the process of trying to make people say photocopying machines for other photocopying machines that are not Xerox. Why? Because they don't want to lose their brand, their trademark rights. They don't want to lose their trademark rights for their brand. And so you can use your trademark rights if you don't enforce the rights to exclusive use of it. But it also, you can lose your rights if you just allow anybody else to use something that's similar to yours that can be confused with your mark. So these are mistakes that you want to avoid. Now, brand protection strategies that go beyond just trademarks. So first is contracts. So Larissa, you hinted at this. When I was in the branding process, I recently did a rebrand earlier this year, and hired a brand designer. Well, guess what? Because I had not started using my brand in business, that means that trademark law did not apply. So what did I do? I had to put it in the contract, because it would not have stopped me from losing my brand if the person breached the contract, but it would have gave me some right to recover under contract law. So you want to put NDAs in place. NDAs are not just for individual contract, but you could also put an NDA inside an existing contract. So my brand designer gave me a contract, and look, let me put this. You have negotiating power before the contract is signed. Before the contract is signed is when you start negotiating what needs to go in. And so I said, I need you to add this clause in here. Actually, what I did is I created another contract to make sure I own the copyrights. That's a whole nother thing, but I own the copyrights for what she was going to create. And then two, I put in a restriction that she could not disclose my brand and she could not publicize anything until a particular date. And the reason why I did that was because I knew I needed time to get the money together and also to prepare and understand how I wanted to trademark my brands. Because remember, when you get ready to trademark, you have to identify the products and services you're going to use it for. So when you're not using it in business, you may not be clear on how you're going to use it in the future. So I had to get clear on that process. Other ways that you can use a contract to protect your brand but beyond trademarks is licensing, putting licenses in place. So if you're doing affiliate marketing, they may use your materials, use your logo. But if you're not using it yet, you're just preparing, you want to put license in place. But even if you're already using it, your license is where it is. Restrictions on use. For many of us, we work with people who we hire them and they put our logos on their website saying, we work with this person. What happens when the public's going after them for something bad press? Your logo is associated with them. And we talked about your brand being your reputation. You don't want your reputation tarnished and your business impacted because they're going through something. And so you want to put restrictions on how someone can use your trademarks so that your brand is protected. Another way to protect your brand is copyrights. And so copyrights have a longer protection term than trademarks. Trademarks are based on use. When you stop using the trademark, you lose your rights. But with copyrights, you can at least get protection for at least 90 plus years. 90 plus years. And it's not based on use, it's based on copyright law. And so it has to be eligible for copyright. So, for example, your logos can be protected under trademark law and copyrights. But your brand is much more than just your trademarks. It's also those pieces of your products and services that are the quality. It goes to the reputation of your business that they can fall under copyright protection as well. Another strategy is well-written policies and licenses. Some of you are hiring people. Some of you have clients. You want to make sure, or you have memberships, you want to make sure that you have well-written policies and licenses and guidelines. How can they use it? What can they not do? And putting notices in place for brand ownership so that they are aware. This is something that goes on your websites, your website privacy policies. Any products, when I do digital products, I have a legal notice section in my digital products. Why? I'm putting you on notice. This is protected, okay? And then last but certainly not least is enforcement and monitoring. So you want to monitor for infringement and enforce your rights with cease and desist letters. You can do that for trademarks as well as copyrights. You want to oppose new trademark applications. So if someone files, then you want to be monitoring for new filings to say, hold up, that is a likelihood of infringement on my trademark rights. Let me oppose this. But that also means, just let me add this, it also means you have to have the money to be able to do this, okay? And then you can also petition to cancel trademark registrations. Now, I can't give y'all, I don't want to put it on the recording. So for those who want to hear this, just stay to the end and I'll say it after the recording ends. But when we talk about enforcement and monitoring, you have to have money to do this. And so one of the things that I recommend is people start a legal fund. What do I mean by legal fund? Put a certain amount of money to the side to create a legal fund out of the money coming into your business every month. It can be as low as $10 every month. Why? Because eventually you're going to need an attorney. Okay. Whether it's personal or business, you're going to need an attorney. So you can start creating a legal fund, and over time, that money will add up. And if you put it in an interest bearing account, then now you have compounding interest that is also adding to growing that, so that when it's time to get an attorney, you have the money there. All right. So again, if you need this slide, you can take a photo of it. This is the option to trademark with legacy. And these are the gifts that you can have. If you reach out by May 1st, you can get your trademark package for $2,000. If you reach out by June 1st, you can get it. When I say reach out, I don't mean just, oh, you contacted us. I mean, you have locked in, you signed the contract, meaning you signed the contract, or at the very minimum, I will honor if you have signed up to do the consultation, because that's the first step before you even get to the package, okay? So these are the deadlines, and then you get complimentary trademark monitoring service. So you can do that just by scheduling a call through our website at legacylegalconsult.com. All right. Now, here's my gift for everyone. You stayed to the end. And so I created an ebook called 4 Tips to Create a Trademark Ready Brand, because you may not remember everything that we cover in tonight's webinar. And so you can download this for free. And remember, I talked about specimens of use. I believe I'm not, I covered it, but you can download that here, and you can get it for free at bit.ly/trademark ready brand, trademark ready brand, and get those 4 tips that will help you when you're in the branding process, help you to remember what needs to be done, that when you create a brand, is actually eligible and can be ready to be trademarked. All right. So are there any questions before we close out tonight? And if you have any takeaways, you can drop your feedback in the chat. Look, thank you. I'm going to honor every single person for coming tonight and being here. You can take a screenshot of this slide as well. Stay connected to us. Follow us on social media. You can also leave us a review by scanning the QR code. But look in the chat, these Q&A time, leave your questions, drop your takeaways, aha moments, feedback. How was the webinar? Let me know. This is question times. I know we went a little over, but we covered a lot of information tonight. So are there any questions before we close out the room? And for those of you who wanted to know what I was going to say, that was a strategy when it comes to trademarks, you can just stay around for a little bit. Yes, I'm on IG and Facebook. I'm also on YouTube as well as, and I'm on LinkedIn for Legacy. You go to Legacy Legal CF, and you should be able to pull that up on Instagram, Facebook, and YouTube. We have some content there, and I'll be putting more content available as well. And then on LinkedIn, you just have to search for the company Legacy Legal and Consulting Firm. And is the symbol and, okay? All right. How was tonight's webinar? Let me know in the chat. Let me know in the chat. But I want to thank those who registered, those who watched the replay. You'll have 2 weeks of access after today. And so it'll come down in 2 weeks on that following Friday. But I want to thank you. The replay will be made available either later on tonight or tomorrow. I hope you got your gifts. Make sure you screenshot this page, as well as make sure you grab your gift. You can screenshot this page as well. And you can also screenshot this page. If you did not do the verification, post on social media, use hashtag BeyondTMWebinar, and make sure you tag me at Legacy Legal CF, Legacy Legal CF. Or you can text. I believe someone asked for the text message. And so what I'll do is when I send out the thank you email, I will put the number in there, okay? All right. So those who are watching the replay, you are not eligible to participate in the challenge. But please, when you do it, you can do it yourself and then post your photo online. Again, I want to thank you for attending Beyond TM, Protecting Your Brand with Trademarks. I am Shayla Jackson, trademark and business attorney and chief legal counsel and CEO and founder of Legacy Legal and Consulting Firm. I want to thank you. You're on my email list. Stay connected. Follow us on social media to keep learning, not just about trademarks, but other areas of law as well. And if you know someone looking for a trademark attorney, please recommend us, send them our way. All right, y'all have a wonderful rest of your night. I'm going to stay around for just a little bit longer. Once I figure out how